Hello and welcome. The clock has just turned 1 o'clock. I'm going to give a minute or so for others to join, and then we will start this afternoon's webinar. Well, good afternoon and welcome everyone. Welcome on behalf of Trust Mediation to this lunchtime webinar, the fifth in our 2026 series. As you will have seen on the screen, this session is being recorded, and recordings are available on the Trust Mediation website, usually within a day or two of the webinar. My name is Tim Wallis, and I'm joined today, as you'll see on screen, by my fellow mediators and hosts. Frances McCarthy. Frances and I were mediating before Trust Mediation was formed in 2006, 2007, and Frances and I were two of the co-founders of Trust Mediation. Similarly, I've mediated for a long time with Andrew Hannam, one of my fellow directors at Trust Mediation. I'd like to make a particular welcome to one of our new mediators, Gerard Martin. And Gerard is one of 5 mediators who have joined our personal injury panel. Welcome, Gerard, and to this, your first Trust Mediation webinar. Thank you very much for joining us. And thank you everyone else for joining us this lunchtime. So our subject today, just to give a reminder of what you've seen on the invitation. These matters, we're not going to discuss them sequentially, but rather all together. We do like to have a discussion, and although we shall discuss the matter between ourselves, we are welcome very, very much your questions and observations. You have on your screen a chat and a Q&A button. Please don't hesitate at any time to add a question or an observation. We're also interested in your experiences of mediation, good, bad, or indifferent. So please do join in, and we will also have a Q&A session at the end. If you wish your question to be put anonymously, please put anon at the beginning of your question, and I will read out this is an anonymous question. So mediation, it is our suggestion, is an ideal process for multi-party, particularly multi-defendant, personal injury and clinical negligence claims. Why do I suggest this? 2 reasons in particular. One is that parties and their lawyers will tell mediators things that they will not usually tell other parties, and this can be very valuable. Secondly, the heat of the dispute, where there is a claim against a number of defendants, is often the dispute between the defendants rather than the defendants versus claimant dispute. And this is often where most of the mediators' work is done on a day which involves a multi-party, multi-defendant mediation. And to give one brief example of this, some years ago now, I was dealing with a claim which involved 6 defendants, and all 6 recognised that the claimant was going to establish liability. There were various arguments, but that basic premise was accepted. But it turned out, as I spoke to the defendants individually, there was one defendant who, as a matter of principle, had made a corporate decision not to pay on claims of this nature. And they were concerned that even if this was a settlement in a confidential mediation, that could give difficulty for them in future claims. When I knew that and had a discussion with the other defendants and found out that 5 defendants would make a contribution, and if there was an anonymous contribution from someone else, that would be absolutely fine. And it was that little stratagem or device which enabled the case to be settled. So that's an example of the tension between the defendants and the mediator being able to find out something in mediation confidentiality, which enabled that final piece of the jigsaw to go into place. We're going to be looking at the scenarios which we have for you, and these will be looked at to some extent through three different lenses. The sequencing lens, which is about the order in which issues are addressed in a multi-party dispute. Whether you start with liability or causation or quantum or contribution, what you start with and where can often be quite influential in getting momentum going towards a settlement. The offers, they sound, and if you wrote them down, they simply look like figures on a page, but each offer can be a message in its own right that can influence what the other parties think, perceptions of risk, and are very important for getting momentum going. And coalitions are important in these cases. If there are 2, 3, or 4 defendants, how the defendants work together or do not on one subject or another. On one issue they may be aligned, on others opposed. And again, the mediator going between the rooms is able to manage and work with the parties on these issues. Does mediation apply today? Well, in the clinical negligence sphere, we know that it does and has been used for some time. In personal injury, sometimes I hear people say, well, it doesn't really work over here. In that case, I would invite you to look at the Grenfell Tower litigation, and that's a prime example of a very large action involving some personal injury aspects, where mediation has been woven into the very complex court timetable, and whether parties like it or not, and there have been objections and there have been issues as to timing, but those reports on the case management of Grenfell are extremely illuminating in how conversant the judiciary are now with the potential benefits of mediation, how and when and where it can be used and where it should not be used. So we're going to start off now by introducing our panel with some war stories, and if you think these are all about very large mass actions, then that is the case. That's where we're starting, but we are going to hone down to the more usual situations encountered in practice where it's one claimant against 2, 3, 4, 5 defendants. Gerard, can I start with you, please? And this is a war story in more ways than one. Would you like to tell us
yes,
about this, please?
This is the Guantanamo Bay mediation, which concerned British residents, Britons who were claiming residence, let's put it that way, who had been captured by British and American forces as those people had tried to join in Afghanistan in the troubles that were happening there, and they were clearly wanting to take part as insurgents within that warfare. So they were want to be terrorists in a way. But that said, I appeared with a number of other lawyers on behalf of, I represented 2 of the claimants. There were about 12 of them in total. This was back in 2010. And the allegations that were made, the action against the government, essentially alleged unlawful rendition, unlawful detention, and unlawful treatment whilst in detention. Allegations of torture were being made within the claims. So they were extremely sensitive matters, and proceedings had begun, but what was anticipated was very lengthy and drawn-out litigation. And this, we were told, when the topic of mediation was first raised, was the first time that the British government had consented to take part in a mediation. So it involved multiple claimants and 5 departments of the government, various departments being involved. So what I can tell you concerns really the procedure of how this mediation was organised and managed. Obviously, confidentiality applies to the substance of what went on, but procedurally, and I think it's illuminating in terms of how you manage a complex multi-party case in mediation terms. So first of all, I'll emphasise the choice of mediator. In fact, in this case, because it was such a substantial operation, two mediators were involved, and the lead mediator, this is important, was Sir Sidney Kentridge. Why was it important? Well, because he was regarded by many as a hero to lawyers generally, to members of the bar. You probably recall that he represented Nelson Mandela and he represented Stephen Biko. So given the nature of what we were dealing with involved serious human rights issues in our case, the fact that we had the personality of Sir Sidney involved was really important. And it was a very wise and sensible choice. So I would firstly underline sometimes the importance of the personality of the mediator and the care taken in choosing the mediator. So it was very important in this case. So there were two, and the second was a more junior silk, and their responsibilities were divided up. I'll come to that in a moment. The next point procedurally to consider was that the venue was kept secret. That was because nobody wanted any press attention, and unless and until the settlement was successful, the fact of the mediation going ahead at all was confidential. So next point. We then proceeded in terms of how we began the mediation to a pre-mediation meeting. Again, that was really important. Some of the lawyers had not met before. There was a chance for lawyers on both sides, the government side and ourselves. For the claimants, there were about 5 legal teams, separate legal teams. So it was just an opportunity to get to know the other side a little bit, to bring some human relationship aspects into the process, and also for us to meet with the mediators, and for the mediators to generally lay down a few themes of how they wanted the meetings to proceed. So that pre-meeting was useful, was constructive. And then on to the roles themselves within. As I say, it was a mediation that took 2 weeks. There was time off within the 2 weeks, but it was spread out over those 2 weeks, partly for the government to take instructions, I think, within the various departments. But it gave time for reflection. So the roles of the two mediators. So the senior mediator led the way, set the tone, and generally took on the role of, certainly to the claimants, emphasising the positives to be gained by settlement. His general presence was just helpful, and he stood back from the junior mediator's role in this case, which was to really emphasise the risks to the claimants if the matter didn't settle. So there was a good cop, bad cop type of relationship going on, or role playing going on, which was effective. I think the other comment I would make is that the very fact that all the claimants were together in this mediation and had been brought together was important, because there was very much a need to consider the group interest in achieving settlement. So there may have been within the group people pulling in different directions, but overall, within the 2 weeks, there was, I felt, a perception, an awareness that other people were involved, other claimants were involved, and to an extent, each claimant had to listen to the other claimants that were in the mediation, and to an extent had to bring into account the goal to be achieved of trying to get a settlement for everyone. Now, that doesn't mean that individual interests weren't put forward. Of course they were, but having the claimants together in it having some group momentum to the negotiation was material to the overall outcome. I'm happy to say that at the end of the 2 weeks, we did achieve settlement. And that was achieved because, again, there was a unanimity of interest on both sides, in that both sides wanted a conclusion. Both sides wanted to get on with their lives, certainly from the claimant's point of view, get on with their lives. The government wanted this whole matter to be settled without exposure to a wider gaze. Let's put it that way. So that's my war story. I hope it's helpful in the sense of the various ways that can be utilised in achieving a useful outcome, a settlement of a complex case. Thanks very much, Tim.
Gerard, thank you, and some lovely themes to draw out there. And I note that what you said about the lead mediator and setting the tone and getting the environment right for the discussions can sound a bit woolly, but it's crucially important in starting to build trust and get negotiations moving. And that's just one of the many things that occurred to me as you were talking. Thank you very much indeed for that, Gerard. Frances, I'm going to turn to you. I'm conscious that when I asked you to talk about the costs wars, not everyone will think back to those, because you and I have been around the personal injury and clinic block for some time now. But tell us, what were the cost wars and how mediation came to be relevant in the multi-party sense in those times?
Yes, thank you, Tim. I mean, it's rather depressing to think how long ago it was, but when you and I were young and youthful, we were horribly plunged into this crisis of the cost wars. What had happened is that there had been an unprecedented level of cooperation following Lord Wolf's introduction of pre-action protocols, because both sides in the personal injury world, supervised by judges and various interested parties, had happily negotiated a system of pre-action protocols, and we were all congratulating ourselves on how well we now work together. And then conditional fee agreements were introduced with recoverable success fees and AT premiums from defendants. And defendants' insurers were outraged by this, as you can imagine, because they suddenly had to start paying out all this extra money without much warning or consultation. And so we were plunged into a desperate state of war, with the level of success fees being bitterly fought over by both parties, to such an extent that I can remember being on holiday and spending time on a sunny afternoon explaining to my husband the calorie and grey, which nobody here will remember apart from you and I, Tim, and how it had gone to the Court of Appeal. And when I saw the glazed look in his eyes, I realised that in fact we'd become too immersed in this. But what happened then was that Tim and I were asked to mediate this whole situation, to see if we could come to some agreement about what the level of success fees would be, so that we would be able to avoid endless litigation. Now, Tim was an experienced mediator. I'd never done any mediation before, but the idea behind it was, as Gerard had said, in a different context, the choice of mediator was one that was very important. And the idea behind choosing Tim and myself was that he was a well-respected defendant lawyer and I was a claimant lawyer. And it was thought that if the two of us worked together, we would be able to persuade people that we could be trusted to try and mediate it in everybody's best interests. And we had a series of meetings in various places around the M25, in these awful venues where you couldn't go anywhere from them, under the auspices of the Civil Justice Council. And we did have a little bit of socializing on the night before a mediation so that we would try and get to know each other, or the parties would get to know each other and be civil. And then we would be plunged into bitter confrontations, really. And it was an absolutely astonishingly steep learning curve for me, certainly, into how these things worked, and the importance of, from a mediator's perspective, of listening and understanding exactly what was behind the different fears of the parties. It wasn't just about the levels of success fee, it was about what was being given away and what was being gained. And it was particularly apparent when we'd done road traffic cases, we'd done employers' liability, we'd done public liability, and we were trying to crack disease cases, and they were tremendously difficult. And we came to a shuddering halt, I think in Dorking, of all places, and we thought that that was an end to it. And we then had the idea of phoning up the leading parties and suggesting we had another meeting, and we walked the main protagonists round a square in London, with Tim and I following behind, while we made them walk round and round and round until they had come to an agreement. But it did show me how the endless possibilities there were if you had external people coming in to a dispute like this and helping people to resolve it. We weren't giving our opinions, although both of us, I'm quite sure, have very strong opinions about where we should land, but we were helping people get to an agreement. It was a proper facilitative mediation, and I think it was such an eye-opener for us that I think it was a big incentive for Tim and I to look to setting up an organisation like Trust Mediation, where we could see what a great benefit mediation was to the kind of work that we've been doing. And if you'd asked me before the cost wars whether I thought mediation was a good idea for personal injury cases in particular, I would have scoffed and said, I'm a negotiator by trade, I don't need any help, I know what I'm doing. But in fact, doing that mediation and all the mediations I've been involved with subsequently has taught me that it is a fantastic weapon to have in your armory. When you want to do the very best for your clients, this is a really useful tool.
Frances, thank you. That trip down memory lane. Andrew, you can recount, I think, some a class action you were involved in. If you'd like to tell us about that one, please.
Yes, the action that I wanted to talk about dates back to 2011. It was a multi-party action against the Cornwall Partnership NHS Trust. Eventually, there were 165 claimants, and I was a lead solicitor in that action. The claims started with some extremely unpleasant abuse that occurred at the Budok Hospital in Falmouth. When we started to investigate, it seemed that every stone we looked under, we found something else. And it was a bit like throwing a stone into a pond. The ripples kept spreading outwards until we eventually had this large group, disparate group of 165 claimants. Our initial plan was to try and identify and litigate a small group of lead cases, which we thought identified the key issues. But progress was slow, and eventually the time came when we proposed a mediation. And the defendants, I'm pleased to say, took hold of the idea in a very positive way. We identified the mediator, Margaret Bowron, 1 Crown Office Row, who I have to say was excellent in the way that she managed the mediation. It was a 2-day mediation, and it quickly became apparent that we weren't going to resolve all the issues in all the cases within those 2 days. But what we did do was we identified a matrix that we could then apply. So the matrix looked at things like, where did the abuse occur? had it occurred in the Bullock Hospital at one end of the extreme, or had it occurred out in the community in independent living units. Was the abuse physical, sexual, psychological, financial? How long were the claimants exposed to that abuse? So these were all elements of the matrix that we got to at the end of the mediation. We hadn't the time and probably hadn't done the work required to populate the matrix, but nonetheless we had that matrix, and that really did break the back of the case. The vast majority of the claimants, almost by definition, didn't have capacity, so we did need to first of all go to the master to get our approach, the matrix approach, approved, which was approved. We then did the workup following the mediation and the establishment of the matrix. We're able to populate the matrix and got all the claimants in the appropriate groups, which it was then simply a mathematical exercise to work out the value of their claims. Each of those still had to be approved, but they were, and the master very much endorsed the approach, which had led to the resolution of what seemed an intractable case before the mediation. So it was a case where I was involved as a lead solicitor, not as a mediator, one of my first exposures to mediation, but was hugely successful in a very difficult case.
Andrew, thank you very much for that. And those are three very different situations, all involving a multiplicity of parties. But as I said earlier, I want to come now to the kind of situation more frequently encountered in practice. And we've got two scenarios to consider. Andrew, I'm going to ask you to help us on the first one, which is more of a clinical negligence one. The second one is a person injury one. So here we're looking at a situation where the treatment starts with the patient in the private sector and moving into the NHS. And this is the scenario here, where there is a private hospital where the initial treatment is provided, alleged breach there. We then get to the next box on our diagram, disputed boundary. Where did the damage become irreversible? Because in the third box, we see the patient went on to an NHS Trust hospital, had further treatment, and there was a further alleged breach. So it is a kind of situation which we come across on a fairly regular basis, that type of case. And Andrew, if I can ask you to put your mediator's hat on and say, what would be your approach in that kind of case, in that scenario?
Okay, well, what I thought might be helpful, just to add a bit of colour to Tim's scenario, is to suggest a factual background to this hypothetical scenario. It is hypothetical, and it is an amalgam of cases that I have both litigated and mediated, and it's this. Patient goes into the private hospital for a cholecystectomy. During the cholecystectomy, damage is caused to the bile duct, and the patient is then referred on to the NHS hospital. In this hypothetical case, there is then a delay in treatment within the NHS hospital. That delay then leads to a delay in addressing the scarring, or in fact, the leakage from the bile duct leads to scarring of the liver, and a delay in dealing with that leak means that the scarring to the liver has become irreversible and leads ultimately to liver failure. So that's just to put a little bit of colour on the background. How do I think that that might best be dealt with? Well, firstly, and this is common to most mediations, I would arrange a pre-mediation call with the parties. In this scenario, whilst both defendants were keeping their powder dry on breach of duty, it becomes apparent that the real issue, the nub of the problem, is causation. So the question is, when did the damage? When was the damage caused? When was the damage irreversible? So that sort of was coming out of the discussions, pre-mediation discussions. The view that I took was that it would be helpful if the parties could expand on that a little in pre-mediation position statements. Parties agreed to do that, so we had a little bit more clarity around the issues that we were going to be mediating. On the day of the mediation, I checked in with all the parties to explore whether there'd been any progress. No, but everyone was now clear what the key issues were likely to be. We had a short opening session. My view is that opening sessions should be fairly short, dealing with introductions, so we all know who's involved in the mediation and the roles that those people will be playing. And after the short opening session, which had established the right atmosphere, so we'd moved from a spirit of litigation and confrontation to one of cooperation. And I think that's quite important to establish that at the beginning of a mediation. After that opening session, I then moved into private sessions. My own view is that private sessions are absolutely crucial. It's an opportunity for the parties to be more open and frank with me than perhaps otherwise they might. It's an opportunity for the mediator to raise challenges and to question the party's position. And in this scenario, the focus of those discussions and my challenges were around the question of causation. So I allowed the parties the opportunity to share their thoughts, and for me, I think it's very important that the parties feel that they have been properly heard in the mediation, rather than being rushed and bounced into early offers. So having done that, and it then became clear where the battle lines were being drawn, I went back and spoke to the defendants, and in fact on this occasion took the opportunity of bringing both defendants into the mediator's room to explore with them what they were thinking. And in broad terms, there was an acknowledgement that they were at risk on liability. They both had differing views on causation, when the damage had occurred, when had it become irreversible. But there was something to work with. The defendants weren't prepared to go further and to make any offers at this stage, but they did invite me to speak with the claimants to see if I could get permission to share with them the sort of quantum that the claimant was looking at. Going back into the claimant's room, and I had, through the pre-mediation meeting, the private chat early on, had begun to build a rapport with the claimant's team, and they indeed were prepared to share with me their settlement bracket. And that was hugely important in the context of this mediation, because I was able then to take that bracket back to the defendants and explain that whatever the schedule looked like, this was the sort of bracket that was going to resolve this mediation. And so what had that done? Well, that had really taken out of the equation some of the very difficult medical legal issues around causation. It made the defendants think slightly different. Rather than focusing on percentages of liability, they now knew how much money between them they were going to have to find. And the majority of the mediation thereafter involved me shuttling between the two defendant rooms as we worked towards finding a suitable apportionment of the pot. And on this occasion, we got there, and it was very positive. The defendants, I think, felt that there was a reasonable settlement. The claimant, although they were less involved in much of the mediation, were of course very happy with the resolution. And that was a good example of how a multi-party or dual defendant mediation can progress. Slightly different approach to the traditional claimant v defendant, but the mechanics, with a little bit of I guess experience and a little bit of taking blinkers off, matters moved forward very successfully.
Andrew, thank you for that. And going back to one of my earlier themes, how parties at a mediation will tell a mediator things they won't tell the other party. It seems to me that in that case, that getting the settlement bracket from the claimant was quite instrumental in reaching settlement that day. Let me go on to suggest that if you got that bracket and the defendants thought it was reasonable, but such was the discrepancy in their expert evidence that they weren't able to agree apportionment, where would that leave you if that had been the situation on the day?
Well, that's a good question, and again, I've certainly had experience of that, and there have been different approaches from defendants, but certainly on more than one occasion, I have been able to persuade the defendants to agree amongst themselves what the global figure would be, that as between claimant and defendants, it was agreed that the defendants would pay the claimants the agreed X pounds. Apportionment was going to be a matter that the defendants would take away and resolve amongst themselves. So we've got to a stage when you say, well, has that mediation settled the case? Well, if you ask the claimant, the answer was very clearly yes. If you ask the defendants, they were pleased that they'd resolved matters with the claimant, and they were comfortable that they had an appropriate working relationship that they thought would allow them to apportion matters. So maybe not a total settlement, but it is certainly a way that if you like, the key issue, i.e. between claimant and defendant, can be resolved.
Thank you. So the claimant gets resolution and the claimant is over. And from the defendant's perspective, the costs on which are running on cease at that point, so far as the claimant's concerned.
Correct. Yes.
Thank you. Gerard, Frances, any observations or thoughts on that before we move on to the next scenario?
No, so I think you do very well, I think, to persuade the claimants to show their brackets. It's a very, very helpful thing for them to do, but it's extraordinarily difficult to persuade them.
I think you're right, Frances. I think that building a rapport with the various legal teams is crucial. That sort of question, without having built a rapport and built a relationship, is probably going to be met with some blank faces. It's very much something that is only going to work if you've built up that relationship in advance.
I've had the scenario as a party where two defendants were simply at odds with each other throughout the mediation, just unable to agree despite the mediator. But what then happened was that one of the defendants took on board the responsibility of settling the claim. And so the claim came out, end of litigation, the claimant, happy that he'd got a settlement. And subsequently, needless to say, the defendants resolved their differences. So there are different ways to end up with satisfaction all around. But leaving the mediation, we thought this was a case between two defendants that would never settle, but in the end it did. So
focusing the mind.
Yeah.
Andrew, Francis, Gerald, thank you for that. Let's move on to our second scenario. And Francis, I'm going to ask you to take us through this. So we're looking at a construction site here, and we've got the usual construction site situation with the main contractor, the subcontractor, the equipment supplier, and everyone's blaming everyone else. The defendants say the claimant's got no liability. The defendants say there is any liability. It was them others and not me. Tell us about situations that you've faced like that, both as a claimant, but then from a mediation perspective.
Well, as a claimant solicitor, I come across this very frequently, and I have in fact just issued a case against 4 defendants on a case which by any stretch of the imagination should settle, because somebody is clearly to blame, but they can't agree on how they're going to bear the responsibility. So we're going to have to go through that whole process, and we will be trying to mediate it. So, and it's a very frustrating and difficult process for a claimant who in these circumstances is generally a completely innocent party, often without any allegations of contrib even, and can't see why his claim can't be settled, just because there's a divergence of view amongst the defendant parties. And what very often happens as a claimant solicitor faced with that is that there are 1 or 2 difficult parties on the other side, to difficult solicitors or difficult insurers who are blocking a potential settlement. And that's where a mediation really comes into its own, because getting everybody in the same room, and we'll talk maybe in a minute about how you actually get everybody to a mediation, but getting everybody in the same room is the absolute key to resolving a case like this. And from a mediator's perspective, it's always difficult. Andrew's already talked about the different approaches of how you have to go about it, whether you try and get to a stage where you talk about the valuation first, or whether you talk about the liability issues and the split in responsibility first is a difficult one, and one you have to, as a mediator, judge on a case-by-case basis. I absolutely agree that in a case like this, it's imperative to have a pre-mediation meeting. Now, my preference when I have my pre-mediation meetings is to have a meeting with the claimants and a meeting with the defendant. That's the usual one. And it's often just really about process. If you're having it by video link, for example, you just want to make sure everything works, or on other circumstances, you want to make sure there are no surprises coming down the track, and all of those sort of normal things that we're used to. But in a multi-party case, what you want to get as a mediator is a feel for the dynamics between the parties, between the defendants, and to get a feel as to whether there is somebody blocking it, whether it's a genuine dispute about the amount of apportionment, or whether it's somebody being awkward, or whatever it is. And you'll get a feel for that in a meeting which is purportedly about the process. So that's my starting point, as is Andrew's, I think. And then you have to get into the mediation proper and decide whether you're going to just abandon the claimant really in his room, with you just popping in from time to time to make sure they're still conscious, or while you spend all your time with the defendants, or whether you try and engage the claimant as you go through the day, because you're looking at valuation as well. Now, I think if you can get what Andrew got on his scenario and get the claimant to quite early on, you having built up the rapport, obviously, with an idea of what their valuation is, it often unblocks a jam between the defendants, because very often for insurers and their solicitors, it's the numbers that matter. And once they know what the final number is, they're perfectly used to having a fight about how they split it. And that kind of debate is much easier for a mediator to handle and to help them to get to a conclusion. One of the difficulties that you sometimes find, though, with this as a mediator is that little coalitions form. And so two defendants, the contractor and the subcontractor in this scenario, might align themselves against the equipment supplier. And they might say, it's completely the equipment supplier's fault, it's nothing to do with us, and we're not going to participate at all because you should be focusing on them. It may be that a coalition like that could be very helpful. In fact, a coalition between sensible parties can often help you move a mediation along, so that you might find that while you're off in the other room talking to the claimants, for example, by the time you come back into the defendant's room, they have in fact had a separate meeting and managed to progress matters quite considerably. So one of the other things I think it's important to do when you, instead of leaving a room and saying, well, look, I'm just going to talk to the other side now, you can have a cup of coffee, you always give them something to do in the defendant's club. There's always a job in a multi-party case for the defendants to do to crack some issue or another. So one of the most difficult things to do as a mediator is to make sure that you're not actually reinforcing a coalition that's going to disrupt the process. What you want to do is to encourage a coalition that's going to help, but you want to be careful that you're not enabling people to freeze out a third party to make sure that they bear the whole brunt of the claim, if that is not in fact what's appropriate. But one of the difficult things that I think it would be good to discuss is where you have a defendant who actually is not the person with the biggest share of liability. Tim has called him Mr. Awkward. Is the person that is defeating the successful progress of the mediation, because he's digging his toes in and he says, I know I'm only up for 5%, 10%, 20% of this claim, but I'm not going to pay anything. And if I dig my toes in long enough, then I'll end up not having to pay anything, because the other two will get sick of it and will want to settle it because they're well aware of the litigation risks and the costs to them of continuing. And in the past, that kind of behaviour could be very beneficial for Mr. Awkward. But there's been a very useful case, the Siemens case, which I think everybody here will want to talk about, which has made it very difficult for a party in a mediation to be as awkward as that. And I'm going to leave it to one of the others to talk about it, because I know they all want to. But what I would say about it is that to get the benefit of that case, which enables you to control a difficult and awkward party, you have to make sure that they actually are attending the mediation. And so in order to do that, you have to not just persuade some of the defendants to come to the mediation, all of the defendants have to be there. And one of the ways in which I think that the recent case law has really helped parties is by enabling us to go to the court and make an application to force defendants to mediate, or actually to force parties to mediate. Generally, I'm speaking with my claimant lawyer hat on. So ever since the case of DKH, I've been looking at every case I have where the other side have refused to mediate, and considering whether you could make an application. And very often what's happened is the mere threat of it has been sufficient. But in 3 cases, I have been able to get an order for mediation. And it's really easy peasy, because you do a statement where you quote the change in the law, you quote all the new changes to the rules, you quote the case of Churchill and Merthyr Tydfil, and then you refer to this case, the DKH retail case, where the defendants put up every possible objection as to why mediation wasn't appropriate, and the judge just knocked them down one by one. And I just go through it all on a bullet-pointed list, setting out all the arguments that the parties had used and all the orders that the court had made, notwithstanding their objections, and pointing out that, in fact, in that case, it did settle once it mediated. And then it's always useful, I think, to mention a number of recent cases and just quote little useful bits from that. I've got lots of examples if anybody wants to ask me afterwards about how it was reasonable to accept an offer of ADR, and there would have to be good reasons shown if it wasn't accepted, and so on. And it's useful to have, of course, a little history to attach to your statement of efforts you've made to persuade the other side to engage in mediation or ADR of any sort, and the kind of excuses or lack of responses that have come from the other side. And then in that way, I think you've got your party to the mediation, and then you can rely upon the Seaman case if you do have that Mr. Awkward with his small percentage of liability who's trying to derail the process.
Frances, let me jump in there and just thank you for that, and you've set that up very, very, very nicely. In terms of the case law, as a question of a matter of balance, I refer to one of our earlier webinars, which was how to say no to ADR, how to say no to mediation. And although there are the very strong cases that you've mentioned, there are a number of circumstances where the conduct of the parties has not been, let us say, exemplary. And they have failed to persuade the court that a refusal was unreasonable. So there are two sides to the argument. But as you say, and we're now seeing certainly in the Bristol court, Churchill orders are being made. Gerard, Andrew, can I just turn to you with the Mr. Awkward scenario when the mediation is running, and the defendant, who everyone agrees is on at least 10%, is simply folding his arms and saying, no, you can pay my share. Gerard, can I start with you on how the Siemens and Super Shield case might apply in those circumstances?
Yeah. I think it helps if I very briefly describe the background to the case, and do want to just read very briefly one of the paragraphs in the judgment. So the background is this: that there was a flood in the basement of an office building in the City of London. The flood caused widespread damage to the building, to its electrical equipment, etc. And there were three claimants. They brought actions against the developer and builder. The builder had subcontracted the relevant work, which was work including a sprinkler system. The sprinkler system had a tank, and the float system within the tank failed. And so it came down to a very simple question of what was the cause of the failure, but that involved several defendants. So highly complex piece of litigation, three claimants and several defendants. A mediation was held. All parties attended the mediation in the case, but what happened was that Siemens, the defendant, took the responsibility of settling the claim with the claimants, settling the case of £2.8 million. So it was a substantial claim. That figure represented just under 50% of the claimed value of the cases. So that was the settlement. Siemens then had preserved their right to pursue Part 20 proceedings against the party they regarded as entirely responsible, and that was
Super Shield.
Super Shield. And so Super Shield, there was a first instance decision before Ramsey J on the issue of the settlement. Ramsey J said the settlement was a reasonable settlement, and that was essentially it. And Super Shields went to the Court of Appeal, Basically, the argument in the Court of Appeal by Super Shields, the awkward defendant, we called him, was this. They said that Siemens had a straightforward and complete defence of the claims against them, and that its settlement of the claim at just under 50% didn't represent a reasonable attempt to mitigate the potential losses in the case. So basically, they were saying they'd given in, and then the under 50% settlement wasn't reasonable. Well, that argument failed. Toulson LJ gave the judgment to the court, and I just think this sums it all up. So he quoted from Mr. Justice McGarry, who once described the law reports as charts of the wrecks of unsinkable cases. Because of its uncertainty and expense, prudent parties usually try to avoid litigation where possible. It has to be borne in mind that the settlement value of a claim is not an objective fact, but a matter of subjective opinion. That's so true. Everyone has their own view as to what settlement value is, taking account of all relevant variables. Often parties have wildly different perceptions of what would be a fair settlement figure. The object of mediation or negotiation is then to close the gap to a point which all the parties find acceptable. When a judge is considering the reasonableness of a settlement, you have in mind these factors and others, that he is this is important, that he is likely to have a less complete understanding of the relative strengths of the settling parties than they had themselves, and equally so in complex litigation. The issue which the judge has to decide is not what assessment he would have made of the likely outcome of the settled litigation, but whether the settlement was within the range of what was reasonable. If he decides that it was, an appellate court will not interfere with his decision, unless there's been some erring in principle, or some unjustifiable decision making, none of which would usually apply. So that is the test, whether the settlement was within the range of what was reasonable. And on that basis, the appeal failed, and Siemens were able to recover all of their settlement from remember Super, the name of the appellant in the case. I'm sorry, Super Shield.
Super Shield, yeah.
Super Shield. So that should bring reassurance to those in that situation where someone is holding out. A defendant takes on the responsibility of bringing a mediation to a successful conclusion, and then pursuing the party who it regarded as responsible for the damage, and finding that the courts supported the mediation, supported the settlement, and the bar is set very high. It's very difficult to overturn what the mediation ends up arriving at when all sides are represented by a legal team, competent legal teams. So that should provide reassurance to those engaged in mediation that the settlement will be supported if challenged, unless there's something extremely unusual has occurred in the circumstances of the proceedings. So is very useful to all those engaged in mediation.
Thank you, Gerard. It's good to know there's Court of Appeal authority to deal with Mr. Awkward, because we do come across those situations from time to time. We're running up to our time now. I've invited questions. If you would like to put any, we can stay on for a little while, but if not, we will draw stumps. I will just mention, was waiting for any questions, that we do have our next webinar planned for the 24th of June. This will be focusing on clinical negligence mediations, and in particular, the opening session. Paul Bain will be our host, and I know that he has invited a number of people from the clinical sector to be involved in that. To mention also that we are continuing to run and recruit for our ADR Champion scheme, and details of that is available on our website if you would like us to provide you with regular information about all matters ADR, mediation, evaluation, and so forth. And I'm looking to see the chat and for questions, but we have none. So in that case, I will bid you good afternoon. Thank you very much indeed to our speakers for the work they've done in presenting to you. Thank you to the audience for supporting us. And for those of you who are watching the recording, thank you also for taking interest in our work. So until the June webinar, thank you and good afternoon. Bye-bye.